How can a musician legally release a cover song? The music business in the US is largely based on two types of copyrights. A musical work copyright protects melodies and lyrics, and a sound recording copyright protects sound recordings. Each of these copyrights grant their owners a set of rights. A musical work copyright owner is granted 5 rights: the right to reproduce the work, create derivative works based on that work, publicly distribute the work, publicly perform the work, and publicly display the work. A sound recording copyright owner is granted 4 rights: the right to reproduce the work, create derivative works based on that work, publicly distribute the work, and publicly perform the work via digital audio transmission. Aside from certain exceptions such as fair use, only the copyright owner or licensee may exercise these rights. What is a cover song? For the purposes of this video, a cover song is a performance of a musical work by someone that is neither the copyright owner of that musical work nor the original artist that performed it. Furthermore, a cover song would not incorporate the original artist's sound recording of that musical work. For example, if Jack wrote a song with original melodies and lyrics and then granted Jill a mechanical license to create and publicly distribute the first sound recording of that song in the US, then Jack would own the musical work copyright to that song, and Jill would own the sound recording copyright to her sound recording of that song. If Kelly wanted to publicly perform or release a cover of Jack's song, then she would need appropriate licenses for the musical work copyright. Which licenses she would need would depend on how she intended to use the cover. However, Kelly would not be allowed to incorporate a sample, a cappella, or instrumental from Jill's sound recording in her cover without Jill's permission. Kelly may recreate aspects of Jill's sound recording, such as trying to sing like her or using a similar instrumental arrangement, but Kelly would not be allowed to use portions of Jill's actual sound recording without getting a license for Jill's sound recording copyright. Kelly would own the sound recording copyright for the sound recording she made. If a musical work is in the public domain, then it is not protected by musical work copyright, which means that an artist can create a cover of it without permission. However, if a musical work is not in the public domain, then the licenses needed to create a cover of it depend on the usage and how it intersects with the rights of the musical work copyright owner. I will go over how the licensing typically works for the following usages of a cover song: live public performance, sales, interactive audio-only streaming, and microsync. Copyright law is foundational to music licensing and music royalties. A musician who is trying to clear a cover song is typically dealing with the rights of a musical work copyright. A live public performance of a cover song is not legally considered a reproduction, a derivative work, a public distribution, or a public display of a musical work. It is considered a public performance of a musical work, therefore a performance license is needed. Typically, a music venue will pay for blanket performance licenses from performance rights organizations such as ASCAP, BMI, CSAC, and GMR. These blanket performance licenses enable a musician in that venue to legally perform a cover of a musical work if it is contained in that PRO's repertoire. The venue would report to the PROs about which musical works were performed, and the PROs would distribute performance royalties to the publishing royalty stakeholders of those musical works. So if a musician wants to legally, publicly perform a cover of a musical work, then they should find which PRO's repertoire that musical work is contained in, and check that the music venue has a blanket performance license from that PRO. A physical or digital record sale of a cover song is not legally considered a derivative work, a public performance, or a public display of a musical work. It is considered a reproduction and a public distribution of a musical work. A mechanical license grants the right to create a mechanical reproduction of a musical work and publicly distribute it. A physical or digital sound recording, such as a vinyl record, CD, or MP3, would be considered a type of mechanical reproduction. The musical work copyright owner has an implied right of first use, which means that they get to decide who gets the first mechanical license to release a sound recording of their musical work in the US. After the release of that sound recording in the US, the musical work becomes eligible for a compulsory mechanical license, which other parties may use to release a sound recording of a cover of that musical work. If a musical work is eligible for a compulsory mechanical license, then the musical work copyright owner is not allowed to prevent one from being issued. However, if a licensee wants more rights or more favorable terms than a compulsory mechanical license offers, then they would have to negotiate a voluntary mechanical license, which the musical work copyright owner could refuse to grant. The compulsory mechanical license system was significantly changed by the Music Modernization Act of 2018. That law got rid of the old compulsory mechanical license and replaced it with 4 new ones, one of which is no longer available. If a musical work qualifies for a compulsory mechanical license, then a musician may get a compulsory mechanical license for physical record sales by serving a notice of intention to the musical work copyright owner prior to distributing the physical sound recording. If they are unsuccessful in locating the musical work copyright owner, then the notice of intention may be filed with the U.S. Copyright Office. There are a number of responsibilities that come with this license, such as paying mechanical royalties at the statutory rate, which is currently 12 cents for each mechanical reproduction of the musical work that is publicly distributed, regardless of whether or not it was sold. If the sound recording of that musical work is 5 minutes or longer, then the rate increases. Other responsibilities are described in Section 115 of Title 17 of the United States Code. A copy of Title 17 may be downloaded from copyright.gov. A musician may alternatively get a voluntary mechanical license to engage in physical record sales directly from the musical work copyright owner or via a mechanical rights organization such as the Harry Fox Agency or Easy Song. These companies partner with music publishers to offer mechanical licenses that are similar to, but not the same as, compulsory mechanical licenses. One difference is that those companies' mechanical licenses may require a licensee to prepay mechanical royalties. A compulsory mechanical license does not require that. As of January 1st, 2021, there is no longer a U.S. compulsory mechanical license that is offered to individual musicians that would allow them to engage in digital sales. However, there is a blanket compulsory mechanical license that the digital music sales platforms such as iTunes and Bandcamp may use. Despite this, a musician is often still required by their distributor or the sales platform to obtain a voluntary mechanical license for digital sales, either directly from the musical work copyright owner or from a mechanical rights organization such as the Harry Fox Agency or Easy Song. From my research, it seems that a couple of distributors charge either a one-time or yearly fee in exchange for obtaining a compulsory mechanical license, presumably an individual download license, for the covered musical work. An interactive audio-only stream of a cover song on a platform like Spotify Premium or Apple Music is not legally considered a derivative work of a musical work. If the platform displays lyrics, then public display rights may be involved, but that is an issue that is usually dealt with between a music publisher and the platform, and not something that a cover artist typically has to deal with. The interactive audio-only stream would be considered a reproduction, public distribution, and public performance of a musical work. To get reproduction and public distribution rights, interactive streaming platforms such as Spotify Premium and Apple Music typically use the blanket compulsory mechanical license that I described earlier and pay mechanical royalties for U.S. streams to the Mechanical Licensing Collective, who is then supposed to pay the publishing royalty stakeholders. Despite this, many distributors still require musicians to get a mechanical license either directly from the musical work copyright owner or via a company such as the Harry Fox Agency or Easy Song. My guess is this is because the distributor might distribute to a platform that doesn't use a blanket compulsory mechanical license, so they want to make sure that they have an individual mechanical license to protect them from a potential copyright infringement claim. To get public performance rights, the platform will typically obtain blanket performance licenses from PROs such as ASCAP and BMI. If a musical work is used in a video uploaded to a user-generated content platform such as YouTube, then that is considered a microsync. A microsync is legally considered a reproduction, a derivative work, a public distribution, and a public performance of a musical work. If lyrics or sheet music are displayed in the video, then it would also be considered a public display, but for this explanation, I will assume that lyrics and sheet music are not displayed in the video. In the case of YouTube, the major music publishers and some independent music publishers typically have deals in place with YouTube that allow its users to upload videos containing the musical works in their catalogs. These deals grant the reproduction rights, derivative works rights, which in this case would be called synchronization rights, public distribution rights, and public performance rights that YouTube needs to host videos of those musical works. The way it works is if a sound recording of a musical work has been uploaded to Content ID, then Content ID can not only detect videos that contain that particular sound recording, it can also detect videos that contain the particular melodies of the underlying musical work. So in other words, it can detect cover songs. If the sound recording and musical work have been registered properly, then Content ID can issue copyright claims on the videos that contain the musical work and, if present, the sound recording. A copyright claim is not as severe as a copyright strike. The copyright claim will typically cause advertisements to be placed on the video in order to monetize the video on behalf of the royalty stakeholders. On the publishing side, the ad revenue may be paid out in the form of mechanical royalties and performance royalties. If the video is a cover song that does not incorporate a sound recording previously uploaded to Content ID, then the cover artist may still be able to receive a portion of the non-publishing side of that ad revenue. This will be paid out by YouTube if the channel is a participant in the YouTube Partner Program. So if a musical work is owned or administered by a major music publisher such as Sony Music Publishing, Universal Music Publishing Group, or Warner Chappell, or a large independent music publisher such as Songtrust or TuneCore Publishing, then a deal with YouTube is probably in place, in which case a video of a cover song would be allowed to remain up but would probably get copyright claimed and monetized. If a musical work is not owned or administered by such a publisher, then such a deal may not be in place, in which case a cover artist should probably contact the publisher or songwriter to see if it's okay to upload a video of a cover of that musical work. Microsync is not eligible for compulsory licensing, so if a publisher doesn't have a deal with YouTube, then the cover artist would have to negotiate a license for the necessary rights, or if they upload without appropriate licensing, they would risk receiving a copyright strike or being sued for copyright infringement. Easy Song's custom licensing service may help a musician license a cover song for YouTube if a deal with YouTube isn't in place for that musical work. I do not know as much about TikTok's procedures for cover songs as I know about YouTube's, but TikTok currently seems to have a somewhat similar arrangement in place as YouTube, though it seems a bit less refined. I would advise that a cover artist seeking to upload a video of a cover song to TikTok consult TikTok's terms of service or, if available, the music publisher of the musical work they wish to cover to find out if it's okay to upload a video of a cover of that musical work to that platform.